Hello, friends. Good afternoon. My name is Ismail Shahtakhtinski. I'm the principal immigration attorney at IS Law Firm. Today is Thursday, September 21, 2023, 12:30 p.m. I apologize for the delay for whoever was waiting for me to join at 12:30. We usually have weekly live stream at 12:30 p.m. every Thursday where we discuss immigration topics and then I answer questions from our audience. Today I was slightly delayed. I apologize. It's 12:43 p.m. right now. So for anyone who joined us now, please subscribe to our channel. Please like this video. That helps us, that supports these live streams, so I can proceed and continue providing these live streams and answering questions from our audience. The topic of today's live stream is immigration judge ratings. Who is your immigration judge, and what is your immigration judge's rating, denial rate, approval rate, and how you can influence, if you can, anything, and what you can do. If you have an immigration judge who you think is not going to be helpful for your case, if they have significant denial rates, or if you review their biography and you think that they're not going to be they're going to be prejudicial to your case. Well, first, how you can look up your immigration judge's denial ratings, approval and denial ratings. That's the first question. There is a website which was created by the Syracuse University, and where they kept statistics of approvals and denials by immigration judges. It started in 2017, and I believe they're still keeping it until now, but the last update was posted in 2022. So I'm posting this right now to the chat section, and it will be also posted in the description of this video, and also in comments, so that in future you can use this website and look up your judge's information, statistics, your judge's approval and denial rates. So you filed for asylum, whether your case was referred to the immigration court, or maybe you entered the United States through CBP-1 process, and now you have court hearing. You know the name of your immigration judge. You can go to this website. I just posted the link in the chat section, and you can put your immigration judge's name and look up the information about their denial rates and approval rates. The other source of information about your immigration judge is if you Google their name, and then, for example, John Smith, immigration judge, and you Google their name, and it will pop up the Department of Justice website, which describes their biography and when they were appointed as immigration judge and which administration they were appointed by. So this way you can review the biography of the immigration judge and, think to yourself whether this is going to be the judge who will be sympathetic to your case, or who will be. I mean, the reality is, what we're talking about, it shouldn't be this way, but the reality is immigration judge is a human being. And as we all know, the political, situation in the United States is such. There is a Republican Party, there is Democrats, there are conservatives, liberals, and each of them have, different attitude or different treatment of immigrants. Conservatives, Republicans, unfortunately, lately have been anti-immigrant posed. Not all of them, I don't want to stereotype, but in general, the Republican Party is using immigration as a tool, as a weapon, as a political tool, political weapon. So to gain more support, to scare their constituents. Democrats and liberals on the other side are, as the name suggests, they're more liberal in approving cases. They're more sympathetic to immigrants and so on. Whether it's a political tool or not as well, but that's not the topic of today. Maybe for some Democrats and liberals as well. So, depending on on which, under which administration, by which president, attorney general was your judge appointed, you can make kind of estimation of what would be your immigration judge's general position or decision making like. As we all know, on the Trump administration, there was the significant anti-immigrant wave, and the government was, trying to put as many obstacles up to even trying to cancel, the DACA Dreamers Act. And, temporary residence for the dreamers, for their work permits. So, they've done a lot of building walls and so on. So naturally, the Trump administration was predominantly trying to appoint immigration judges who were less sympathetic to immigrants, or, so to say, maybe strict in applying the laws and regulations, or interpreting them in a way as to restrict immigration into the United States. So naturally, a lot of those judges had higher asylum denial ratings. They were more skeptical of the asylum applicants and so on. So if you see that your judge was appointed by, Attorney General Sessions or Barr or on the Trump administration, then you'll probably run into a judge who is, has higher denial rates. But that's not to say that every judge is the same. Again, it doesn't apply. This rule, this theory doesn't apply to every judge. There are individual decision makers, and some of them may decide differently, without regard to which administration, which attorney general appointed them as an immigration judge. So you can review this biography of the immigration judge. And the other factor you want to review is if you have an immigration judge who used to practice in private practice law, or was a public defender, or was representing individuals in courts against the government, those immigration judges may understand your position or your attorney's position better. They may be more sympathetic to your case or to your attorney's arguments, or open-minded about it. But versus an immigration judge who used to be a prosecutor in the past, who represented the government, or who may have been a prosecutor in immigration courts, those immigration judges with those backgrounds, they may understand better the other side, the opposite side in your immigration court case, in your removal proceedings. So the biography of the immigration judges, as I said, it's public information. You can look up on the Department of Justice website if you Google the name of the immigration judge. But other than that, as I said, the denial rating and approval ratings, you can look up at this website by the Syracuse University, where they keep the statistics of the asylum denial and approval rates of immigration judges. Now, what if you see that your judge has higher denial rate than other judges in the same court or nationwide? Should you panic? No. The answer is no, because there are many different factors that play a role in denial rates or approval rates of immigration judges. And one of them is where this judge is currently, which court is this judge working, and what type of cases predominantly this judge presides on. So is it, more of the cases somewhere close to the southern border, where lots of Latin American cases, from Central America, then the denial rates are probably going to be higher, because the volume of the immigration from those countries, from Central America, from Mexico, and so on, is so much higher than from anywhere else. And a lot of those arrivals, individuals who come from those countries, are coming to the U.S. More for economic purposes versus political situation. Again, not to stereotype, there are different types of cases that are perfectly, approvable asylum cases from Central America, from South America, but still, they have much higher rate of denials because they are either gang related, or there may be some statutory bars to those cases and so on, versus somebody who's coming from Eastern Europe, for example, from Africa and so on. And again, part of it is not because they are Central Americans or they're from Africa. The difference is, to come from anywhere else in the world, you have to fly here. Rarely someone gets on the boat to arrive in the United States nowadays. So you have to fly here, and to fly here, you have to have a visa. And if you had a visa, most likely you already went through some kind of vetting and so on, versus somebody who comes into the US border, southern border, and enters the United States, and then they get apprehended, and after that they file defensive asylum. So those are much weaker cases versus somebody who enters the US with a visa and then affirmatively files for asylum. So that's why those types of cases may have higher rate of denial. And if your immigration judge has been presiding over the cases that are predominantly from Central America, then you may see a higher denial rate. And even the Syracuse University at that website writes, and I don't know where exactly it is on that web page, but you can look it up. There was a judge who had like 88% denial rate, and when this judge was transferred to another immigration court, and now they had 80% or so of the approval rate somewhere, may have mistaken about the numbers, but it was much higher approval rate than before when the judge was transferred to another immigration court. And the reason is, as I said, it's because of the types of cases this judge was handling I believe it was somewhere in Miami, Florida, where this judge was before, in immigration court, Miami, Florida, or somewhere else in Florida, and then was transferred to up north. So, if you have a judge, say, in our area, Washington, D.C. area, which has higher denial rates, then that's different. Then, you should be a little bit cautious. But also, still, some judges, the immigration courts, they assign certain types of cases to judges. Lots of judges handle only detained cases. Detained cases meaning they're handling the cases for, they're listening and deciding on asylum applications by individuals who are currently in immigration detention. They're not released. They didn't apply affirmatively. They have some issues, either some criminal issues here in the United States, or they entered the US illegally and so on. So in those cases, you're probably going to have higher denial rate versus immigration judges who handle primarily referred cases from asylum office. It used to be more visible, more contrast in the past between the types of cases each judge handled. Then lately, I think it's mix and match. Sometimes I see an immigration judge, though still detained and non-detained, is strictly divided. But in terms of types of cases, whether some immigration judge is handling primarily cases from Eastern Europe, versus cases from Africa versus cases from Central America, it's more mixed now. But if you have an immigration judge who has high denial rates, is there anything you can do about it? Now, there is, by law, by regulation, there is nothing you can do to change your judge. You cannot, other than ask the judge to recuse himself or herself, if you can prove that this judge has some kind of prejudicial predisposition, what's we call predisposition against you or your type of case. But that's very hard, high burden of proof. You probably heard of, recently Trump trying to recuse the judge in Washington, D.C. in the federal court in the case against him, saying that this judge previously made statements. So anyway, we're not going to go too deep into this topic. That's very rare and very unlikely that you can file a successful motion to recuse the judge. And you cannot do it based on the denial rates. You cannot say this judge denies too many cases, I don't want this judge. So that's not your choice. But what happens if you move to another jurisdiction? So, immigration courts, they are regional, they have regional jurisdiction. So some places, some states have multiple immigration courts. For example, here in Virginia, we have two immigration courts, Sterling and Annandale Immigration Court. It used to be combined as one, Arlington, which had the jurisdiction over West Virginia, part of the West Virginia, because part of it falls under Pennsylvania, Philadelphia Court, and then Virginia, North Carolina, and so on. But then they created a lot more immigration courts and so on, so that now, even Maryland has two immigration courts. It used to have Baltimore, now it's Baltimore and Hyattsville. So if you move from a jurisdiction of one immigration court to another another immigration court, your case is not going to automatically move. You or the government need to file a motion to change venue. And if you do, unless there are any specific exceptional reasons, the judge will grant. Every judge, even those judges who have higher denial rates, they're happy to get rid of your case. And almost every government attorney, unless they've been deeply vested in your case, they have done investigations and there are things that they were excited about, they're not going to oppose change of venue. When you need to file that change of venue, is something that needs to be decided. It has a tactical effect on your case, on your employment authorization, for example. So if you have filed for asylum, you're waiting 150 days before you can file for your EAD, your clock will stop unless your 150 days have already come and passed. Then your clock will stop and you will have significant delays in your EAD if you file change of venue before your 150 days after filing for asylum, or even before 180 days, because it takes 30 days for them to approve it. So you have to accumulate 180 days. So scratch 150 days. 150 days is when you can file, but then 180 days is the number of days you have to accumulate before being eligible. So if you file change of venue and the venue changes before that, then your clock will stop. So make sure to discuss this with your attorney if you move to another state. That other thing, disclaimer I need to make is that you are not supposed to, and ethically I cannot and I don't recommend, to move to another state just because you don't like your judge. But you should know that if you do move to another state, you can change your court by filing the motion to change venue. The other thing I want to let you know is that do not use fake addresses. So sometimes what I see is asylum applicants who have cases in immigration courts, they look up their judge and they say, oh, okay, I've heard that the courts in New York are better, more loyal, they approve more cases, they have higher approval ratings. So I'll use my friend's address in New York and I'll pretend that I live there, but I am actually living in Michigan, or I'm living in, Atlanta, Georgia, and, doing something. Don't do that. That's very, first of all, it's illegal because you're misrepresenting information to immigration court. Anytime you file something or anytime you are in immigration court, whether in your master hearing or individual hearing, one of the first things that the judge asks is your address still blah, 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 blah. And, if you misrepresent that's misrepresentation, then that significantly damages or basically makes you non-credible witness. And if you are, then everything you say is not going to be credible enough for you to get asylum, or that can be actually found as misrepresentation, intentional misrepresentation, which may be a ban for benefits such as green card down the road after your asylum. So, don't do it. And you have to realize you're dealing with the federal government of the United States. You have the prosecutor, so to speak, we call them assistant chief counsel of Immigration and Customs Enforcement, who's the attorney, the prosecutor in immigration court. And they work with the U.S. federal government. They're part of the U.S. federal government. Then you have immigration judge, who's an employee of the Department of Justice. Different from the federal civil courts, criminal courts. The immigration judges, immigration courts are not part of the judiciary system. They're part of the executive branch of the U.S. government. They're part of the Department of Justice. They're kind of like internal check by the executive department on the decisions of the asylum officers and so on. And they have to have this immigration proceedings before a judge can order removal, before the order of removal can be issued. So it's so to speak, it's like, not fake, but it's internal. It's within Department of Justice, immigration court, immigration judges. So anyway, bottom line is that you're dealing with the U.S. federal government. You have to understand that they have ways to find out. They have ways to find out, as we all know from, this scandalous story of Edward Snowden, that the federal government can actually monitor your computer and they know where you are. They know where you're connected to internet. They can find out where you bought, Starbucks coffee this morning. If you bought Starbucks coffee this morning using your credit card, I mean, theoretically, I'm not saying they do that. I'm not saying the government attorney in your immigration case is going to get a warrant and get your bank statements and so on and so forth. But anything you do where you actually physically live, you're leaving lots of traces. You're leaving lots of traces. You have mailing addresses which become public. You are getting loans, you get some bank statements, you get some documents, mail coming to your address where you live, and so on. Anyway, the reason I'm telling you this is not to, teach you how to hide from federal government, but to actually tell you that you cannot hide from the federal government. And if you use a fake address, meaning an address of your friend, and you pretend to be living in New York or California because those are, are known as more liberal courts. If you do that, the government can easily find out, and if they find out, that's it. You screwed up. First of all, they'll transfer the case back. Secondly, you are already misrepresented information. Now you are not credible as a witness. You're impeached as a witness, and then anything you say is not going to be credible or counted even for your case. So don't do it. Don't use fake addresses. Don't listen to someone who told you that, oh, I did it, it worked. Yes, things happen. I know somebody who jumped off the roof of the 9-story building and survived. It doesn't mean that everybody should do that. So there are people that get caught, and that causes serious problems. But if you do move, if you are, sometimes I have clients who are moving around a lot. They work temporarily in one state, and then they have the residency, they have the house, or rent, or place where they store their personal belongings and so on in one other state. Then they should, of course, keep their address and be there, even though they're temporarily working somewhere. So anyway, just reasonably, if you move to another state, you have to notify the court within 10 days that you moved, file the notice of change of address. Don't immediately file a motion to change venue. Consult with your lawyer. Typically your lawyer has to change your address, file something with the court, and we usually do that for our clients. For anybody who joined us now, my name is Ismail Shahtakhtinski. I'm the principal immigration attorney at IS Law Firm. This is our weekly live stream on immigration topics every Thursday, 12:30 p.m. New York time, Eastern Standard Time. We have live stream. Today's topic was the immigration judges' ratings. What you can do if you have higher denial rates from the judges. As I explained, don't put all your eggs in one basket. May not have any meanings. Some immigration judges who have higher denial rate, they may actually approve your case. One other factor I always, a argument that I bring up is that imagine there is an immigration judge who has higher denial rate because they have a significant amount of cases from Central America, which are either gang related or, drugs related, or, economical basis, basically, meaning doesn't have the person applying for asylum doesn't have much basis. Imagine that there are those types of cases and your judge has 80% denial rate. And then you come in with your case, which is, let's say, political case or ethnic case from some other part of the world, from Middle East or wherever the part of the world is. You have some, interesting facts and so on. That judge with higher denial rate may be more likely to approve your case because your case stands out among all of the cases that this judge was handling. So anyway, what you should take from this session is that don't put all your eggs in one basket. Your judge's statistics have some meaning, so you should look and you and your attorney should consider that. Your judge's background, biography is a factor. It should be also considered, but each one of them individually should not be a factor. Most important factor is the type of case you have, your preparation for the case, the evidence, and obviously the attorney that you work with, how you prepare and you present your case. Those are the most important factors, despite whoever the judge is, despite their denial or approval rates. So, because it's not really a lottery, prior cases may not have, your case may not have the same outcome as the prior cases. So please subscribe to our channel. Please like this video. Anybody watching us now on live stream. I'd greatly appreciate if you click that like button. That helps us very much. Anyone who's watching us on social media as well, thank you so much. Please like and please subscribe to our Facebook page so you can be notified of the future live videos. Again, every Thursday at 12:30 p.m. we have this live stream. As long as I'm available, I'm not in court, so currently I'm not, but I was delayed slightly. Anyway, I'll go now through the questions posted by the audience in the chat section, and I will answer one by one. Hello, Ismail. Success depends more on statistics of the judge or from prosecutor. Could you give us best formula for success in immigration court? Thank you again for being with us every day, Thursday. Stay home. Berdia, thank you for your question. Yes, so it's a mix of all those things. And as I said, it's not just the immigration judge's statistics. The success depends primarily on your case, how you prepare for your case, and how you present your case. Then comes, I would say, the immigration judge's background and statistics, and then the prosecutor's background and statistics. So the prosecutor, the assistant chief counsel, some of them may be more understanding, more open-minded, more educated. Some prosecutor may be more willing to stipulate on things that are obvious, and some government attorneys, they get their role wrong, despite the head chief of Immigration and Customs Enforcement issued a memo to all these prosecutors telling them, look, your role is not to put obstacles or to do everything to deport the applicant or the respondent in removal proceedings. Your role is to find justice, and sometimes you don't want to make it a hell for the applicant, but you want to know more, you want to find the justice and work with the attorney representing the respondent, the applicant, to try to find out and stipulate to things. Sometimes agree to things. Sometimes you can even agree, come to court, and we have that happen frequently, where we come to the court and the government attorney from the beginning tells us and the judge that they agree to the grant of asylum based on the evidence they have seen, based on things that we filed. Recently, about 6 months ago, I had a case where the government attorney said that I've read the asylum officer's decision and I agree that the decision was wrong. So the asylum officer, it was a referred case, the government attorney at the hearing basically said that, I think the asylum officer was wrong in the analysis. So it was not factual. It was not a case where the asylum officer believed that somebody misrepresented information or was inconsistent in their story, but it was just simply that the asylum officer made a legal mistake in law, and the government attorney agreed and said, yeah, we're going to agree to asylum. So that happens frequently too. But sometimes government attorneys, I don't know if they have personal issues or with asylum applicants or with the attorneys representing them, they think their role is to be a jerk. I'm not saying that, again, government attorneys are jerks, but some of them think that that should be it, and they kind of behave themselves as I don't know, they got stick up in somewhere. So then that's not supposed to be. I mean, we should be friendly. We're both officers of the court. We're trying to get to the justice and get the information about the case. So it's case by case, basically. But there is no best formula for success. Best formula for success is to prepare thoroughly. Well, I just said there's no formula, but the best formula is to prepare thoroughly, to consider all of these factors together, and to have to do everything you can to get your case granted, approved. And the best way you do it is you preparation and have the competent, experienced lawyer who's going to help you with that. Okay, so the next question, and if anyone has any questions, it doesn't have to be necessarily related to the topic of today's live stream. You can post your question in the chat section, and I will do my best to answer every question. All right, the next question is, like Skinny Gecko is asking, sir, as a non-American who came here a few months ago by U4U sponsor program, so you're from Ukraine, Slava Ukraini, I would like to hire an immigration lawyer such as yourself in order to help bring my mother to stay with me. Possible? Yes, of course. There are multiple ways for the Ukrainian nationals to come to the United States. Now, you as a U4U beneficiary cannot sponsor your mother. You cannot bring her. U4U stands for Uniting for Ukraine, and this is the parole program for Ukrainians. They have similar programs for Cubans, Nicaraguans, Venezuelans, where they can come to the United States through humanitarian parole process as long as they have somebody in the U.S. who files a sponsorship. It's a fairly simple process. It's better than coming to the border and using CBP-1 to enter the United States. This is more orderly and so on, but it's been delayed. It was much faster. Now it's gotten delayed. Part of it is because of the criticism by the Republicans, which part of it is true, and I agree. In the beginning, not U4U, but primarily CBP-1 was two open doors. Basically, my clients were reporting that they were coming, and a lot of them were from Russia. Those were individuals from Russia who, were trying to avoid conscription by the Putin's regime, or they were opposing, or they may have protested against the war in Ukraine. And they were coming through CBP-1, and I was shocked. They would come, young males, some of them in 30s, some of them even 40s and so on, but they would come through the border, CBP-1. It would take them about 5 days, and they were not asked a single question. Basically, border agent would just review their documents, their passport, IDs, and they would let them in. And obviously they would have NTA, notice to appear in immigration court. So this was the CBP-1 process. Now it's significantly delayed. It takes about 2 months. And the same way U4U program is taking a lot of time. Part of it is because now they kind of realize that, hey, we need to do more vetting, more background checks. I think, that's just my guess. That's why now with CBP-1, some of the clients that entered recently tell me that they waited about a month and a half to 2 months in Mexico before they had the appointment with the CBP officer. So that's something to consider. But yes, you can hire a lawyer, and the lawyer can help to discuss. And the best thing before hiring a lawyer is schedule a consultation. And when you hire a lawyer for something, obviously it costs $1,000 or so on. But you pay $250, for example, in our case, for the consultation. And then once you decide you want to hire us, if there is something to hire for after consultation, realize, yes, I want to work with this lawyer, then this consultation fee you paid doesn't get lost. It's still your money. It's applied as a credit towards your future legal fees. So I just posted the link for the consultation, and I believe it's in the description of the video also. If not, I'll put there. So this is the link for scheduling consultation. When you click this link, you will come to the page where you can find answers about all of the answers to questions about the consultation, our terms of consultation. And then you will, if you click the schedule a consultation link in that page, you will be taken to a calendar which shows available times and dates, and you can just select the date and time where I will contact you either online. If you want me to contact you via WhatsApp, I can. If you want me to, contact you via Skype, Zoom, or phone call, either way, it's fine. So you will make that decision. So use this link to schedule a consultation. We can talk about it, and maybe there's something you can do yourself after you discuss with me over the phone. All right, the next question is Nuraldin. I crossed border from point of entry, applied for asylum. My I-94 DT is expiring soon. Should I renew it? Thank you. No, there is nothing you can do to renew your DT. So if you cross the point and they paroled you, which DT stands for, I don't know what it actually, the abbreviations mean. I think deferred something. But anyway, so it means parole. You've been paroled for the purpose of being able to enter and apply for asylum. The fact that you applied for asylum makes you lawfully present. So you don't have to have a parole. You don't have to file for anything because you are now lawfully present in the U.S. and you're pending your asylum application. So there is nothing you need to file. But thank you for your question, Nuraldin. All right, for anybody who joined now, please post your questions in the chat section if you have any, and please subscribe to our channel. Please like. Every Thursday at 12:30 p.m. Eastern Standard Time, New York time, we have this live session where I discuss immigration topic. I just talked about immigration judges' ratings, and now I'm answering the questions from our audience. All right, so Kai is saying, hi, sir. Good morning. Is it normal to not receive your affirmative asylum division for more than 2 months? I guess you meant a decision. not division. Yes, it is. It's unfortunately it's normal now more than it used to be. Sometimes it takes 6 months, sometimes 1 year. We had cases that waited for 2 years for the decision. There is always this delicate consideration whether you want to push to make the decision, but then at the same time you're thinking, okay, if they're like looking into something in this case, and that's why it's taking so long, and the reason why they're looking, I mean, if they were to deny the case, they would have already denied it. If they're taking this long, maybe to look up something about somebody that may have been mentioned in your case, should we push them? And if we push them, the asylum office will just simply refer it to immigration court, basically deny it, and then now you have to go to the immigration court and start it all over again. So there is always this delicate thought process with you and your attorney. Should you push on the decision making or not, or just let them take? I would say, maybe after 2 years of wait time, you should definitely. After 1 year, probably up to 1 year, I would give some slack to the asylum officer and the supervisor of that officer to take their sweet time to decide on this. Again, because you don't want to push them, you don't want to piss them off. The asylum officers and asylum office, they have, unfortunately, due to the way the system is, they have almost unchecked authority, discretion. And the reason why it's unchecked is because if they deny your case goes to immigration court, the USCIS loses jurisdiction over your case. Now your case is under the jurisdiction of EOIR, Executive Office of Immigration Review, which is part of the Department of Justice, which is a different agency of the U.S. government. So different department. The USCIS is not the Department of Homeland Security. So the USCIS officer's decision almost goes unchecked because they just refer it. That's it. There is nothing you can do. If you contact the asylum office, complain to the supervisor, they're not going to care because they have cases backlogged back to back. They're not going to be, caring about your complaint and so on. So the asylum officers have wide discretion. Don't try to push them too hard or piss them off by sending these mean emails. Why are you sitting on my case? And I've seen that happen. I've seen people who've been interviewed for asylum. I don't know if they believe that the US government owes them to approve asylum. No, asylum is a discretionary benefit. It can be denied on discretion basis, not discretion which is not valid, but it has, good moral character and so on. All of that has effect. But still, you don't want to be angry at your asylum officer who's deciding your case, because they have wide discretion and it's almost unchecked. There is this loophole basically in the immigration system. The judge's decisions are not unchecked. The judge's decision can be appealed to the Board of Immigration Appeals. So not only the executive branch of the US government, the Department of Justice, created immigration judges so that there is this formal process, which is similar to the judicial branch of the US government, where there is a judge, where there are adversaries arguing, but they also created Board of Immigration Appeals, which basically considers the decision. So there are more judges in that board that decide whether the immigration judge made the mistake. So there are multiple checks in the Department of Justice processes, but in the USCIS, in the Department of Homeland Security process, there is no check. The asylum officer makes the decision, voila, that's it. Your case is gone. It's either went to the immigration court it's basically thrown to the Department of Justice saying, here, you deal with it. And sometimes I see asylum officers in a perfectly approvable case, but just because the officer is not well educated, is not, doesn't have a clear understanding of the political situation in that country, and that's part of what we do. We have to explain it to the officer. That's why having an attorney present at your interview is very helpful, to kind of hold on to the officer and say, no, look, this is not the way you may think about it, but here's what's going on and so on, and describe the country conditions and so on to the asylum officer, providing the written reports and also making an oral statement. So, but anyway, sometimes they just throw the case to the Department of Justice, to the immigration court, just because the asylum officer was not bright enough to understand or to be able to decide this case, because it was complicated case, there was complicated dynamics in the country of the applicant and so on. So unfortunately, that happens quite often, and I see that happening, and there is no checks. Now, there is a process where, at one point in some interviews, probably in the 16 years of my practice, I had about 3 interviews where I had to call the supervisor, replace the asylum officer, because they were so dumb. They were asking, questions that are so unrelated to the case that it was basically prejudicial. It was obvious that this asylum officer is basically out of line or doesn't know anything about the case or anything about the country of persecution. I had an asylum officer in a case where it took us probably 30 minutes to explain what is this country where the applicant. And I said, are you prepared? This is asylum interview. You're deciding the fate of this applicant. And the questions you're asking, first of all, you cannot even pronounce the name of the country. You should have prepared. I'm not saying you should know this as an asylum officer. You should be born with knowing what this country is or where it is or the politics of it. But as an asylum officer who's tasked as part of our federal government, you should study and prepare before having this interview where you're going to ask questions. And based on your scribbles that you write, you're going to make a decision 1 or 2 weeks or maybe 6 months or a year after, based on those notes, on the fate of this family. And you don't even know how to pronounce, or even you don't even know that there is a country like this that exists on earth. So those types of cases, yes, I've had issues called supervisor replaced asylum officer, and thankfully most of them, I think all of them time that it worked, the cases were approved. But that's not the point. The point is, you don't want to push too hard on your asylum officers, unless again there is no other way, because they have a wide discretion. Right. Ricardo is asking, hello, Mr. Ismail. I'm here with B1, B2 visa, meaning visitor visa. I filled my visa application form as married, but I never had any legal document to prove that. Now I want to file for asylum as single. Is it possible? Ricardo, you're either married or you're not married. You're either single or married, okay? The fact that you had no legal documentation to prove that is irrelevant. So again, you're either married or not married. Now, the word married is a legal term. So it's since you're filing for asylum, you're filling out these forms and so on, they're not asking whether you consider yourself married. The question is simple: are you married or not? If you went through a legal process of marriage in any country in the world, which counted as marriage in that country, then you're married. If you did not, let's say you and your civil partner lived together and you thought that you considered that he or she was your spouse, but they were not, and then then obviously you were not married. So I don't think it matters whether you have legal document or not. You're either married or not. Now, if you're married, you just don't have legal document here, then you can contact someone. I'm sure there are services in the country, and I don't care which country you are from, saying that no, there is no way to get a marriage certificate or proof of marriage from my country. Well, again, there is, during the peak of atrocities in Syria, I know, and I had some Syrian clients that couldn't do that. There was no one. Basically, there were not even lawyers, legal services there who could actually get that. But that got fixed. Now we have some clients from Syria that are able to get copies of their birth certificates reissued and so on. Afghanistan and so on. In Ukraine, again, that also got fixed. In the beginning of the war, there was no way basically to be able to get those civil documents from Ukrainian government because nobody knew what's going on, and the government kind of paused and didn't know what's going to happen next day. We all remember that, February 24th last year. But now it's everything is normal relatively in terms of the government operating and issuing civil documents. So anyway, bottom line is, Ricardo, if you're married, get someone, at least exercise your efforts to get it. If you cannot still get that document that you're married, then you can show that I hired somebody in my country, and they tried, and here's a letter, here's a confirmation that they couldn't find, but I know that I legally married. So yeah, so basically don't make inconsistencies. And if there is inconsistency between those two applications, your B1, B2, your visitor visa, and now you're filing for asylum, then be prepared to have a thorough explanation. The best thing is not to have inconsistency. For example, sometimes I'm asked in a situation like this, right? You got a B1, B2 as married, but now you think maybe you were not married, not because you don't have documentation, but now that, I told you, you think, oh, maybe I was not legally married, but I was, let's say, religiously married. In that case, it doesn't matter what you put in your asylum application to the answer to that question, a single, married or not. What matters is you disclose everything. Disclose this. So you can put married in your asylum application, and then in the addendum to the asylum application, disclose it. Tell the officer or judge, whoever is going to review your asylum application, that right there that I thought I was married, but then I realized that I'm not married legally, or I may not be legally married. Anyway, bottom line, I selected married because I also selected married in my B1, B2, but I'm not sure if I'm legally married or not. So as long as you disclose this issue in your asylum application, it doesn't really matter whether you put single or married. So at one point, it will have to be decided either by the judge or the officer, or you will find out throughout the process. But anyway, the bottom line is disclose that in the addendum. And that refers to many other things. Sometimes people tell me, oh, I don't think I was detained. I don't think I should say yes to the question if you have been detained. Yeah, I was stopped at the border returning to my country from a foreign trip, but I don't think it was detention. Oh, I don't think it was arrest. I wasn't placed in handcuffs, although they took me to a station. I don't think it was arrest. The bottom line is it doesn't really matter whether you put yes or no. It matters whether you disclose what happened. So if you don't think something, if you think something, that probably means you should disclose it in the addendum in your application. So don't just put an answer and hope that they'll not notice. All right, so HSN is asking, is there a bar for denied asylum after entering with CBP1? What if asylum seeker is married to a green card holder? So no, there is no automatic bar, but the bar is if you're applying for asylum based on the same reasons that were previously denied, then you will probably not be approved unless circumstances changed. So the new judge is not gonna decide whether the previous judge made a mistake. If they see that the case was denied based on the same facts. Now, if you have significant changes, then your case can be considered de novo, meaning as a new case. What if asylum seeker is married to green card holder? Well, I guess your question, it's missing a lot of other things, but I'm assuming what you're saying is that if you as asylum seeker marry a green card holder, can you apply for a green card? The answer depends on how you entered the United States, whether you have a status other than asylum seeker. Generally, the answer is no. So if it's a U.S. citizen and you entered with CBP1, then yes, you can apply for adjustment of status. If you married with a green card holder, you're waiting for asylum, you don't have a status, because you entered with CBP1 is not a status, it gives you authorization to remain in the U.S., then in that case, you may have to leave the U.S. to go through consulate. It's a complicated process. You don't have to do it now, but at the end, when the interview is scheduled at the consulate, you may have to leave the U.S. All right. Nane Brian is asking, if you applied for asylum online and later on you are placed in removal proceedings, will the asylum process stopped? No, it will not stop. So if you applied for asylum online, what means, with the USCIS affirmatively, and then if you're placed in removal proceedings because you were detained or so on, then your asylum case will basically be terminated there, but you have to file the asylum paperwork with the immigration court. So it's not stopped, it's just transitioned, but you have to refile it with the immigration court. So now the immigration court has jurisdiction and they will decide your case. But you should notify the asylum office so that they take you out of their docket, their calendar. Otherwise, they're going to be upset if they book an interview for you and then realize that you have a removal proceedings, which means they don't have jurisdiction over your case. When a judge and the prosecutor, so M. Abdul is asking, when a judge and a prosecutor have a high denial rate in asylum case have been approved, will this help the person to get green card or citizenship right away without inconsistent? I don't. Oh, okay, I understand what you're saying. So you're saying, does it help if a judge who's a tough judge who denies many cases, does that help if that type of judge approved your case? It's an interesting question. No, the answer is no. They don't keep track. So the USCIS doesn't keep track of immigration judges or review, was it a tough judge who approved your case or was not? Immigration judges, they have their decisions have the same weight. Now the BIA may see lots of Board of Immigration Appeals may see more denials from one judge or more appeals from one judge or more mistakes because they are considering the mistakes of the immigration judges. So they may not informally keep tab of decisions of the immigration judges and so on and their denial rates. They may see lots of errors from one immigration judge versus another. So yeah, it's possible. But again, not to answer your question, no, the USCIS, citizenship, green card, and so on, it doesn't matter which judge approved your case. But that's an interesting question. Thank you for your question. Thank you, everyone, for your questions. So these are all very interesting questions, relevant, on point, and I will do my best to answer everyone's questions, although I may not be able to answer questions from the repeat audience members because I want to make sure that everybody's question is answered before we end. I'm past my time, but because I started a little bit late, so I will continue. Again, thank you everyone for joining. Please please subscribe to our channel. That helps me a lot so that I can continue this and that we attract more audience and we can have longer sessions or more frequently so everybody's questions are answered. Okay. Verdi is asking Mr. Ismail what to do in order to convince judge and government attorney before a hearing to approve asylum case. You cannot convince the judge before the hearing, you can convince the government attorney. So your lawyer should prepare and file. Number one, what we do is we file prosecutorial discretion request. So there is a special format that the government, the prosecutor and immigration government attorney wants us to send them these requests where we present all of that. Well, you have to first make sure that your case is complete, meaning you have filed all of the evidence, documents, everything that is supporting letters, country conditions reports, expert reports, and so on. You file it with the immigration court. Now, the judge is not going to review your case until either shortly before the hearing or at your individual hearing. Unfortunately, they're so busy sometimes they may not be able to even review your case until the day of your hearing. So, but in terms of government attorney, the government usually doesn't assign an attorney specific to your case until very close to the hearing. If you file a prosecutorial discretion request, which is still a good idea, not to dismiss your case, but to actually agree to asylum, your attorney can obviously do all that, but it's not very likely that it's going to be granted by the PD request itself, but it will be very helpful to prepare the government attorney for the possible agreement when they get assigned. Typically a week or two before the individual hearing, the government, the chief counsel's office, ICE, they assign attorney to your case and they prepare for it. And if they see this PD request, and if it's has convincing evidence and arguments and so on, the government attorney may agree to asylum. So there are many different factors that play a role. I mean, again, sometimes we see the government attorneys not agreeing as part of PD request before the hearing, but on the day of hearing, they agree to asylum, or they come to a hearing and they agree to limit the hearing to just specific one point, which is also greatly helpful. So doing PD requests, trying to kind of convince the government to agree to the relief, to asylum or cancellation of removal before the actual individual hearing is always a good idea. Obviously, it may cost you more. Your attorney may charge more for this certain additional services, such as doing that. But it's worth it because that's the decision in your case that will basically ultimately result whether you or your family can live together with you in the here in the United States. So Ilir Uka is asking, what happens if you are on medical therapy who impact your memory? Does your interview is going to be credibility at USCIS? If you have a medical therapy which impact your memory, you should have medical records of that. And you should bring it and you should discuss that with the asylum officer or the judge before meaning before the beginning, at the beginning of the hearing or interview, and you should present those medical records. And I wouldn't only just do records, I would also get a narrative from your medical therapist, whoever thinks that it impacts your memory. I mean, better yet, you should probably contact a neurologist, medical doctor, and get an opinion report about the effects, and be as clear about this as possible, and still do your best to answer the questions as much as you can. So, what I don't like happening is sometimes if somebody makes a mistake, or the government attorney or the judge says, or the officer says, but you said this there and you said this now, and then the applicant says, I have some medical condition from 10 years ago. Maybe that made me inconsistent. That's not a convincing argument. Don't use that, again, unless you have the medical records. And if you have this issue, since you are asking me this question here, that means that you have this issue which is concerning to you, then bring it up to your lawyer if you have a lawyer in your case. If you don't, it's a great idea, and you should hire a lawyer, especially with your mental condition, or with the memory condition. But if you don't, again, you have to discuss that with the officer, provide the evidence, proof, opinion report beforehand, so that you're not put in defensive after they catch you with inconsistency. And then you'll work together with them to deal on this. Nur al-Din is asking, removal proceedings are dismissed by court, applied with USCIS. Is it considered affirmative now? What are the odds? Okay, great. So if it's been dismissed by the court and you apply with USCIS, it is considered affirmative. Once you apply with USCIS, it is affirmative. What are the odds? That's not a lottery. There is no odds in asylum cases. It depends on many factors: your preparation, your presentation, your evidence you gathered, your case story, what happened to you, the country conditions in your country where you're from, and the asylum officer and their understanding of your case, their level of expertise or knowledge or preparation for your case. So there are so many different factors that there is no odds, in fact, in asylum cases. Mustafa is asking, what do you do after approval from a judge? After approval from a judge, you need to have an appointment with the USCIS office, with the local USCIS office, where you will be issued new I-94 form. You do not need work authorization anymore, because once you get asylum approval, you are allowed to work. You are work authorized incidental to your approval. So you have to have an appointment at the local office. How you do that? You can do it two ways. Up until a month ago, you could only call the USCIS 1-800 number, and on the phone to get to the person, you would say, I need InfoPass appointment. InfoPass appointment for the purposes of this, for getting your I-94 at the local office. But now the USCIS also began doing the online appointments about a month ago. So if you just Google USCIS appointment, it will take you to that place, and you can set up the appointment. They will contact you, give you the date and time when you can go to the local office with the judges, with the order from the judge, since you got approval, with the approval order, and they'll give you the I-94s for you and your family members. And then guess what? You can apply for a green card. The reason why you can apply for a green card so early is because the government changed the policy, and because it's taking so long. So first, by law, you are eligible for green card after asylum after spending 1 year physically in the United States. But you can apply before that, considering that it takes the USCIS about 1.5 to 2 years to review those cases. So by the time, if you file for green card now, by the time the USCIS officer reviews your green card case after asylum, you will have already accumulated 1 year of physical presence. So that's why they allowed now to file earlier. Is it theoretically possible that the officer will review a case earlier than 1 year and deny it? Yes, it's possible. So typically we advise our clients to wait maybe 3 months to 6 months before applying. This changed this year. Basically, in the before this, you had to wait for 1 year, 1 calendar year after approval of your asylum to file for your asylum. Now you don't, because it takes them so long to review it, so they let you file it so you don't lose more time. Asylum officer, so next question. Abdul is asking, asylum officer and immigration judge, which of the approval has more influence when filing for green card? Thank you. Abdul, there is no difference whether it's asylum office or immigration judge. Well, typically asylum officer who approved your case. Well, let me take it back. So there is no influence whether it's immigration judge or asylum officer. Once you file for green card, it's all technicality. It's not, there is no discretion. There is nothing you need to prove other than, you didn't do anything bad, like committed crimes, or that there is no inconsistency. If you apply for a green card after asylum, you have to be very careful so that there is no inconsistent information or anything that could be interpreted as misrepresentation, either in your green card application or your asylum case. Now, if you had immigration judge approve your case and you filed for a green card, and the USCIS believes that there may be a possible inconsistency, what they will need to do is they will need to contact Immigration and Customs Enforcement, get the chief counsel to review all this, and maybe file a motion to reconsider with the immigration court in light of this new information, and then reopen your case and maybe get immigration judge to vacate the order. And that's going to be such a big hassle and headache for the government to do. So in the case of immigration judge grant, if they can avoid doing all that, they will. Now, if the case was approved by the USCIS and they see inconsistency, ever so slight, it's not that difficult for them to reopen your asylum case. So they can simply send to the asylum office, which is also part of the USCIS, and tell them, hey, we have this information. This guy in the asylum case was saying that he was detained at the protest, but in filing this I-485, he says, no, he was never detained. There is question as to that in both of the applications, and look into this. And the asylum office can say, okay, send him back to us. We will do another interview. Even though we approved asylum, we can take it back at any time. So to answer your question, Abdul, if the case is granted by the judge, you have stronger layer of protection from having your case reopened and reconsidered. But that layer is not, it's just a technicality protection, meaning it's bigger hassle for the government to reopen it. But if you have an inconsistency, no matter which way, one way or another, you're going to have big problems. So don't file for your green card on your own. If you're after asylum, don't file for citizenship. This is one of the most frequent traps that I see people falling into is when they get asylum approved, and then they get excited and they handle their green card case on their own, the citizenship case. In the forms, documents they provide, there are inconsistencies down the road between the asylum application and this. And then they get into big troubles. They get in immigration courts, cases reopened, and so on, and that becomes problematic. So don't do it. I've seen cases where there was no inconsistency in the papers, but at the citizenship interview, they got asked questions about their asylum case, and they provided inconsistent information, and that became a big trouble. So don't do it. Hire a specialist for someone to handle these citizenship and green card cases. Stans is asking, is it obligatory to file I-589 form evidences with 100% USA notarized documents? No, there is no notarization requirement whatsoever in anything you file with the asylum office or immigration courts. So forget about the notary. These are from, lots of third world countries. Notary has this godlike meaning that, this means this document is serious, or what is written in the document, if it's notarized, it becomes more truth, which is not. In the United States, that's not the case. Notary simply notarized confirms that the person who signed is that person. So there is no notarization of documents needed when you file any of this. Sometimes I see individuals from those countries, from third world countries, where they bring these documents, translations, let's say a passport or internal document, birth certificate, and a translation of it with translation bound with all those ribbons, red gold stamps, and then the translator's certification is notarized that this is true translator. I don't know, whatever that might be. And then they attach these things anyway. It's like a document, from the kingdom of whatever at one point 200 years ago, where the people on the horses would come and open this document and read to the public. So yeah, the United States doesn't do any of that. There are no stamps, there are no things that are required. Now, based on the country you're from, there may be stamps required depending on the civil documents. But the State Department has a web page where for every country they describe what the document should look like from that country. So if you have a birth certificate, what it looks like, or if you're getting marriage certificate or police certificate, where it's from, by who it's issued, and so on. That's the State Department report. But anyway, the translation evidence, they don't need any notarization. HSN is asking, does denied asylum with CBP-1 prevent you from applying for F2 visa in the future? Yes, anytime you applied for asylum, I don't think denied necessarily, it has to be denied. If you applied for asylum, whether it was denied or whether you withdrew or so on, obviously if you apply for F2A, meaning family 2, so it's spouses of permanent residents. All right, well, F2A stands for category of the family-based petition by the permanent residents. Well, the answer is yes. If you were denied asylum, first, why you were denied? Was it inconsistency? Was it a material misrepresentation? Or was it just because they didn't think you were able to prove that you deserve asylum? So that's one question. Second question is, once your asylum was denied, did you maintain your status in the United States or not? If you didn't have a status after the denial, was your case referred to immigration court, or was it just denied and you were left in the US, or did you voluntarily depart? And if you are in the United States after denial, you didn't have status, what did you have a gap between your lawful presence before you find? I mean, there are so many questions to ask. So you should, I think I changed the question. So HSN, you should consult with an immigration lawyer. It's not something that you're going to get a full and complete answer in the public forums or even live streams with me. So get a lawyer, consult with a lawyer. You can always use our link that is provided here and consult with me. You can schedule a consultation. I'll be happy to give you full advice when I find out. All right, so I think I answered the question, at least one question from each of the audience members. Let me answer the remaining three. But anyone who joined, I greatly appreciate it. That would be really, really nice if you could press like button or press thumbs up in Facebook or YouTube where you're watching. I would greatly appreciate that. So Ricardo is asking, can someone on a visit visa get married to a green card holder and have the possibility to have a green card? What are the chances for someone on B1, B2 visa to get asylum? So yes, it's a possibility to get a green card as long as the visitor's visa didn't expire before the time of application, meaning visitor status didn't expire. What are the chances for someone on B1, B2 visa to get asylum? It's same as any other statuses. So it doesn't matter which status you had in the past. For your asylum, anyone can qualify for asylum as long as you have basis for it. Can asylee with a pending green card staying abroad with refugee travel document more than 6 months apply for naturalization after 4 years of receiving green card, or do you have to wait an extra year? No, if you stayed more than 6 months before you applied for naturalization, but less than 12 months, then you can still apply for naturalization, but you have to prove that you maintain close ties. So if before you apply for citizenship, you have to qualify, you have to meet the requirements of continuous presence and physical presence. Continuous presence means you were not absent from the United States for more than 1 year during a single trip during the last 5 years. And but if you were more than 6 months but less than 1 year, you have to prove that you maintained your close ties. So you can still fall under exception if you can prove that you maintain close ties. None is asking, sir, if your asylum was transferred from USCIS to court due to removal proceeding, will you still be eligible to apply for work authorization after 150 days? Yes, you can still apply for work authorization after 150 days. although you may have to have the court administrator do a correction, because the asylum office will terminate your asylum case, but the court will open new asylum case since you're going to file your asylum application with the court. And since because of that gap, you may have to deal with the court administrator to fix your asylum clock to account for the days that you had already passed before you were placed in removal proceedings. Your lawyer can contact the court administrator. It's usually basically a clerk, an administrator, somebody who works at the immigration court that has the authority to change the clock in for your EAD. All right, so it's 1:52. I think it's been more than 1 hour. I greatly appreciate anybody who joined. I greatly appreciate the questions. Lots of really interesting questions. I enjoyed answering them. Please join us every Thursday at 12:30 p.m. Eastern Standard Time. Sometimes I have to reschedule it. Sometimes I'm unable to do it, but so far so good. We have been consistently every Thursday, 12:30 p.m. Eastern Standard, New York time. I've been able to join you all and answer the questions from our audience and talk about immigration topics. Today we spoke about immigration judge ratings, how their biography, background, and rating, denial approval ratings may affect the outcome of your case. If you missed the beginning of this live stream, once it's finished, you can rewind and look and listen to the beginning. And I greatly appreciate if you like this format, and if you like these live streams, if you enjoyed asking your questions and getting your questions answered, please excuse me, please press like, please subscribe to our channel so you'll be notified, and most importantly, please send us all your friends, relatives, acquaintances who may be bothering you with immigration questions because you are in the United States or you applied for asylum. They think you know the answers to everything, and they may be bugging you about the questions. Tell them, here's an immigration lawyer, doctor of jurisprudence of the United States, immigration lawyer with more than 16 years of experience, answering questions online, live stream every Thursday. If you did not have a chance to ask the question on live stream of this video, you can post your question in the comments, and we will do our best to answer all of the questions. Thank you so much. Have a nice rest of the week and great weekend. Bye-bye.